Hello, sir. Hello, sir. Good evening, sir.
Hello. Good evening.
Sir, can you hear me? Audible இருக்கா sir?
நீங்க கேக்குது, நான் பேசுறது கேக்குதா?
ஆமா சார், நீங்க பேசுங்க.
ஓகே. இப்போ ஆடியோ ஆன் பண்றேன். இது வீடியோவும் பார்க்கறேன். இது சரியா இருந்தா பாத்துங்க.
சரியா இருக்கு சார்.
சரியா இருக்கு இல்லையா?
ஆமா சார்.
ஓகே. சோ நான் இப்போ 3:30க்கு நான் வீடியோ ஆடியோ ஆன் பண்ணி பேசுறேன் நான்.
சரிங்க சார்.
ஓகே.
Thank you, sir.
Thank you.
Shruti ma'am, audible இருக்கீங்களா ma'am?
Hello.
Shruti ma'am.
Audible இருக்கா ma'am?
Audible இருக்கு ma'am.
Okay.
Hello. Hello. சொல்லுங்க சார். Yeah, good afternoon. சொல்லுங்க சார். Yes, sir. Yes, sir. Hello. Hello.
Hello.
Hello.
Hello.
கேட்கவே இல்லையே.
Hello. Am I audible, ma'am?
Is it Shruti?
Yes, madam.
Yeah, Shruti. Maybe you can show your video also.
Okay, madam.
Yeah. Yes, Shruti. Perfect.
Okay, ma'am. Okay.
Thank you. Yeah.
Thank you.
ஓகே
ஸ்கிரீன் ஷேரிங் இது பண்ணணுமா? பிரியா ஸ்கிரீன் ஷேரிங் பாத்துக்குமா சாரோட?
ஸ்கிரீன் ஷேரிங் பண்றேன் இருங்க.
அது கொஞ்சம் பாத்துருங்களே 1 மினிட். அதுக்கு பேரலலா அட்மிட் பண்ணிக்கோங்க.
அட்மிட் பண்ணிடுமா எல்லாரையும்?
Thank you.
தனியா இருக்கா? சரி. சார் போன் பண்ணா
கண்டினியூ கொடுத்துறேன்.
Branch admin, please keep everyone in mute.
Okay, ma'am. Okay, ma'am.
Speaker sir, you need any support, sir? Sridharan sir, that's help வேணுமா sir?
Muted. Sir, please
நான்
unmute.
அத மட்டும் சீரியஸ்
Shall we start the program, sir? Sridharan sir? You are muted, sir. Kindly unmute yourself. Sir, you are muted.
சார் ஸ்ரீதரன் சார் மியூட் பண்ணிட்டான்.
Kindly enable the screen sharing. It is not enabled. It is disabled.
ஓகே சார், நான் செக் பண்றேன்.
சார் 1 செகண்ட் சார். 1 செகண்ட் சார்.
என்னங்க இருக்கு? அவளுக்கு அவ மட்டும் தான் தெரியும். ராஜு கூட கிளாஸ்ல அவங்க மட்டும் தான் தெரியாது. யாருமே
For the benefit of members, your membership numbers need not be put in the chat box. So once you've registered and you're attending the meeting, automatically your attendance will be posted. So you can use the chat box for putting information with respect to your queries.
Is it enabled, Priya?
Just a minute, ma'am.
Enable பண்ணியாச்சா மேம்?
Shall we start, Chairman?
Sir,
ஆரம்பிச்சலாம் மேடம் ப்ளீஸ்.
Priya, please.
good afternoon, members. We're very happy to welcome you all for the successful third day session of our series of programs on corporate laws. So we are having this program today on oppression and mismanagement in company law by Sridhar sir, Mr. A.M. Sridhar, Advocate Chennai. I would like to welcome Shruti to introduce our speaker. Please, Shruti.
Good afternoon. It is my proud privilege to introduce this session's eminent speaker, Advocate A.M. Sridharan sir, who will be sharing his insights on the topic oppression and mismanagement in company law. Advocate A.M. Sridharan is a Master of Commerce, an associate member of the Institute of Company Secretaries of India, and a Bachelor of Law. He has wide and diverse experience for more than 3 decades and has worked in various capacities as the Deputy Registrar of Companies, Bangalore, Karnataka, Bench Officer, Company Law Board, Chennai, Assistant Official Liquidator, High Court, Madras, Group B Officer in the Offices of Registrars of Companies, West Bengal and Tamil Nadu, worked as Auditor in Office of the Accountant General, Chennai. He has given more than 75 opinions under the Companies Act, Karnataka Stamp Act, Presidency Towns Insolvency Act, and SEBI Employee Stock Options Regulations. He has contributed a number of valuable articles, like article on shareholders democracy and e-voting in company cases, article in the Moneywise magazine on the topic, the Companies Act 2013, whether it should be scrapped, paradigm shift from Company Law Board to NCLT and NCLAT in the July 2016 issue of the Management Accountant Journal, published by the Institute of Cost Accountants of India. He has also delivered numerous guest lectures on a wide range of topics at various forums. It includes incorporation of companies, merger, acquisition and amalgamation, a bird's eye view of the Companies Act 2013, along with rules of interpretation organized by the Bangalore chapter of ICSI, oppression and mismanagement, drafting of petitions, stages of cases, court drafts, case studies at Hyderabad. To name a few, there are even more numerous guest lectures that have been delivered by him. It is my privilege to introduce this eminent speaker. Thank you, sir, for joining us today. Over to you, sir.
Sridharan sir, you'll have to unmute yourself.
Thank you for the nice introduction. Then the topic given to me is the oppression mismanagement in company law. Now, you know that earlier the oppression mismanagement was regulated by section 397 and 398 of the Companies Act 1956. Under the Companies Act 2013, those sections have been clubbed together and a single section, section 241, has been brought into force. If you read section 241, subsection 1, class A, it says any member of a company who complains that the affairs of the company have been are being conducted in a manner prejudicial to public interest, or in a manner prejudicial or oppressive to him or any other member or members, or in a manner prejudicial to the interests of the company. You will find in a manner prejudicial to the interests of the company under the Companies Act 1926 in section 398. Because in my view, a company cannot be oppressed. A company can only be mismanaged. So now, part of this class A, section 241 subsection 1 class A, pertains to oppression and in a manner prejudicial to the interests of the company pertains to mismanagement. This is what I just want to introduce this. Now, if you find, you will also find earlier under 397, it was oppressive to member only you will find. Now you will find prejudicial or oppressive to member or any part of the members. That is what you will find now. Now, this class B, section 241, subsection 1, class B, if a material change takes place in the management of the company or control of the company, either by transfer of shares or by composition in the board of directors of the company, and such a change likely to result, the affairs likely to result in the company's affairs be affected prejudicially. That was earlier under 398. Now under section 241 subsection 1 class A, class B, they have also added it will be prejudicially conducted against the interests of the members or any class of members. So this section 241 is an amalgam of oppression and mismanagement both. That is why you will find the heading of the section, application to tribunal for relief in cases of oppression, etc. That etc. stands for mismanagement. Now, 241B, I have already said. Then, now, section 241 subsection 2 is equivalent to section 401. Earlier, the central government was empowered to bring a petition before the company law board when the affairs of the company have been conducted in a manner prejudicial to public interest. Now, 401 has been incorporated in section 241 subsection 2. But earlier under section 408, the central government had powers to make an application to company law board seeking direction to supersede the board of directors and appoint other directors in the board. That particular section 408 has not been incorporated in the 2013 Act. But of course, under 241 itself, the NCLT is incorporating in appointing the directors by superseding the board of directors. Now, one important issue which has cropped up under the Companies Act 2013 is section 433 says the provisions of Limitation Act 1963 shall, as far as may be, apply to proceedings or appeals before the tribunal or the appellate tribunal as the case may be. Now, as a result of this section, the NCLAT in this case, Esquire Electronics Inc. versus Netherlands India Communications, particular case law, NCLAT Esquire Electronics Inc. versus Netherlands India Communications Enterprises Limited has bifurcated the acts of oppression falling within the period of limitation and falling beyond the period of limitation. Then paragraph 12, it said, the NCLAT said, we agree with the finding of tribunal that section 433 of the Companies Act 2013 makes it clear that the provisions of Limitation Act 1963 apply to proceedings or appeals before the tribunal or appellate tribunal, as the case may be. The tribunal also rightly held that the petitions under section 397, 398 are enforceable like decree, and for all purposes a suit within the meaning of the Code of Civil Procedure. We also agree the finding of the tribunal that the suit for which there is no prescribed period is provided as per Article 113 of the Limitation Act. The period of limitation is 3 years. For the reason aforesaid, we agree with the finding of the tribunal that the appellants cannot rake up any issue which is barred by limitation of a period which is 3 years prior to the date of filing of the petition. And in the same decision, the appellate tribunal in para 19 also held, for the reasons and finding as recorded above, we set aside that part of the impugned judgment dated 6th October 2016, passed in company petition number 108 ND 2016, insofar as it relates to maintainability of the petition for the period 2013, 14 and 15 onwards, and remit the case to National Company Law Tribunal, Principal Bench, New Delhi, to take decision on merit, limiting the prayer with regard to alleged oppression mismanagement, if any, made between the year 2013 and onwards. So NCLAT, see, previously the NCLT has dismissed the entire petition itself as barred by limitation. But on appeal, the NCLAT concurred with the decision of the tribunal that the matter brought before the tribunal under section 397 and 398, because this was filed under the old act. But of course, by the time the NCLB was abolished and NCLT and NCLAT has come into picture, they are like a suit, because the remedy is enforceable like a decree. Because remedy is enforceable like a decree, the matter filed under section 397, 398 is in the nature of a suit. So in this connection, we should see the Limitation Act. The Limitation Act says, section 3 of the Limitation Act says, if any suit is barred by limitation, the court is duty bound to dismiss it, even if the defendant do not take objection. So the court has to see on its own whether the matter is barred by limitation, and it has to dismiss it. And under the Limitation Act, you have got Schedule 1, Schedule 2, Schedule 3. Schedule 1 lays down time limit for filing the suits. Schedule 2 is the time limit for filing the applications. And Schedule 3 is the time limit for filing the appeals. In Schedule 1, there is an Article 113. It says wherever no time limit is provided, a period of 3 years would apply. Because under section 397, 398, no time limit is given, unlike transfer of shares under section 58, where it says in case of a private limited company, where the communication has been issued by the company that your share transfer cannot be approved, then you will have to file the petition within a month. And if the company has not given any communication, then you will have to file within the period of 60 days of the lodgement of transfer of shares. No time limit is given under the section 397, 398. Therefore, the Article 113, a maximum period of 3 years would apply. So in this case, certain events have taken place prior to 2013. Those events are barred by limitation. And the events which have taken place 2013, 14, 15 shall have to be looked into. So the matter has been remanded back to the NCLT for giving decision on the events happened after 2013, 14, after 2013 onwards till the date of filing the petition. The principal bench of the NCLT in another case has summarily dismissed the petition because that petition itself was filed on 1/10/2015. The alleged acts took place in the year 2009 to February 2012. Therefore, on the date of filing the petition was hopelessly barred by limitation, and therefore the NCLT has dismissed the petition. So this is the new legal impediment which has come into place for the people who want to approach the NCLT in cases of oppression and mismanagement. But now you have to see, under the Insolvency and Bankruptcy Code, also the NCLT dismisses the application on the ground of limitation. But only thing you will have to see, the Honorable Supreme Court in BK Educational Services Private Limited versus Parag Gupta, because when this petition was filed originally, the section relating to the limitation was not included in the IBC. That section was subsequently included by an amendment. And the Supreme Court has said, under the IBC, for applications filed under Section 7 and 9 of the Limitation Act, Section 7 and 9 of the Code, IBC, Limitation Act is applicable since the inception of the code. If default occurred over a period of 3 years prior to the date of filing the application is barred by Section 137 of the limitation, save and except in those cases where Section 5 can be applied to condone the delay in filing such application. My only submission is, see, in so far as the petition under oppression and mismanagement is concerned, the adjudicating authority is the same. Adjudicating authority is the NCLT and NCLAT. The adjudicating authority has taken a view that for a petition filed under oppression mismanagement, because the remedy is enforceable like a decree, it is in the nature of a suit. Therefore, Article 113 of the Limitation Act will apply. Once Article 113 of the Limitation Act applies, if the matter is barred by limitation, it has to be summarily dismissed. The delay even cannot be condoned. But under IBC, the Honorable Supreme Court in BK Educational Services Private Limited and Parag Gupta, it said the Article 137 of limitation will apply. So Article 137 is the period prescribed under the Schedule 2 for filing the application. In Schedule 2 for filing the application also, wherever there is no time limit is provided, a maximum period of 3 years will apply. The only difference between the section oppression mismanagement and the IBC is now, because Article 137 will apply, the Honorable Supreme Court has said, now under Section 5 of the Limitation Act, if for any reason a petition cannot be filed within the period of limitation, the court has got the power to condone the delay under Section 5. In case of a suit, the court cannot condone the delay. The court cannot condone the delay. Okay. So this is the decision of the Supreme Court in this case law. But I am only worried the corollary of this, okay, for the purposes of oppression and mismanagement, whether NCLT is treated like a court, because Limitation Act applies to the regular courts of civil judicature. Okay. And for the purposes of limitation, whether NCLT is treated as a tribunal, meaning other than the court, other than the court of civil judicature. So this is one thing. Then another judgment of the Supreme Court rendered under Section 271 in Devas Multimedia Private Limited versus Antrix Corporation Limited, that is in relation to this ISRO espionage case. Okay, this particular company was ordered to be wound up under the ground Section 271 Class C. 271 clause C, the affairs of the company is conducted in a fraudulent manner, or the company was formed for fraudulent unlawful purpose, the persons concerned in the formation and management of its affairs have been guilty of fraud, misfeasance, or misconduct in connection therewith, a company can be ordered to be wound up. And for that, the petition has to be presented by a central government, by a person authorized by the central government, or by the registrar of companies. 272 says who can file the winding up petition. Okay. And in this case, the Honorable Supreme Court has held, if you go through this particular paragraph down the line, as rightly pointed out by the tribunal, that is the lawyer tribunal, NCLT Bengaluru, a singular act of omission or commission may constitute fraud. And even a series of acts may constitute fraud. A fraudulent act may be different from fraudulent manner in which an act is performed. Okay. The words conduct of the affairs of a company in a fraudulent manner, because this says fraudulent manner, indicate that the process was a continuing one. If the conduct of the affairs of the company in a fraudulent manner is a continuing process, the right to apply becomes recurring. In the next paragraph 8.33, paragraph 8.23, the Honorable Supreme Court has said, therefore, since the fraudulent manner is a continuing one, the provisions of Limitation Act do not apply. Now let us come to section 241 once again. 241, what does it say? The 241, I will read it once again because I have broken that section in the PowerPoint. Any member of a company who complains that the affairs of the company have been or are being conducted in a manner prejudicial to public interest, or in a manner prejudicial or oppressive to him or any other member or members, or in a manner prejudicial to the interests of the company. The only difference is there the manner, the word occurs after the word fraudulent. In 241, the manner word occurs prior to the words prejudicial and oppressive. So, in my opinion, this particular application of limitation maybe has to be revisited at some point of time. Then, if you come to this, the good old judgment rendered by the Honorable Supreme Court in Shanti Prasad Jain versus Kalinga Tubes Limited, meaning of oppression, para 20, as already been indicated, it is not enough to show that there is just an equitable cause for winding up the company, though that must be shown as preliminary to the application of section 397. It must further be shown that the conduct of the majority shareholders was oppressive to the minority as members, and this requires, this is most important, that events have to be considered not in isolation but as a part of a consecutive story. So this is most important, the Supreme Court decision in this particular thing. Events don't consider it in isolation, but consider it as a part of a consecutive story. Suppose today you go and file a petition with the NCLT alleging acts of oppression. There have been transfer of shares. There have been allotment of shares. Okay. Then non-conduction of AGM, etc. If the allotment of shares have taken place prior to 22 means 19, somewhere in the 18, and 19 transfer of shares takes place, and thereafter some AGM convened, you have not got the notice of the AGM. I am asking, because Honorable Supreme Court has said that events have to be considered not in isolation but as a part of a consecutive story, The allotment of shares which has happened in 2019, be that as it may be, it might have happened prior to 3 years. But it says events have to be considered not in isolation, but as a part of consecutive story means, okay, the allotment happened in 2019 also should be taken up for considering oppression, and it cannot be dismissed that it is barred by limitation. This is what I want to say. Okay. There may be a possibility. There is a possibility of only one transfer of shares or one allotment of shares, which has happened prior to 3 years. After that, if no acts of oppression, no events have taken place, then it can be dismissed as barred by limitation. But if some acts have taken, I can't say acts, events, if some events have taken place prior to 3 years, and some of the events have taken place within the period of 3 years, and because of the Supreme Court judgment that events have to be considered not in isolation, but as a part of consecutive story, the entire events have to be considered for the purpose of deciding whether oppression has happened in the company or not. So this is what. So Deva's multimedia judgment says fraudulent manner means manner implies it is a continuing one. Then 241, you have manner prejudicial to public interest or manner prejudicial or manner oppressive to any member. Okay. Therefore, this Deva's multimedia judgment and the Shanti Prasad Jain judgment combined together will give you a clue that if part of the events have happened prior to 3 years and part of the events have to be happened within the period of 3 years, then all these things have to be considered together because they are part of a consecutive story. And part of the thing cannot be dismissed as barred by limitation. So this is what my humble opinion. Okay. Then this particular word oppression is not defined under the Companies Act. In fact, if one happens to read the judgment of the Honorable Supreme Court in Cyrus Mystery case, it traces the genesis of the oppression from the English Act, how this word oppression has come, and also in Indian Companies Act, how it has come. So one has to go through the judgment, how this has come into the statute book in England as well as in India. Okay. The Honorable Supreme Court in this judgment, after going through all the 4 cases of the English courts, held finally that it says there must be continuous acts on the part of the majority shareholders continuing up to the date of petition. This is because are being conducted in the old act. Now have been is also there. Because have been is also there, if the oppressive acts have stopped at some point of time, then you have to consider the 3-year period. Okay. Continuing up to the date of petition, showing that the affairs of the company were being conducted in a manner oppressive to some part of the members, the conduct must be burdensome, harsh, and wrongful. So the petitioners who approach the NCLT, they have to prove to the adjudicating authority that the conduct of the respondents are burdensome, harsh, and wrongful. Okay. They cannot say there is a mere lack of confidence between the parties. And the Supreme Court went on to say that mere lack of confidence between the majority shareholders and the minority shareholders would not be enough unless the lack of confidence springs from oppression of a minority by a majority in the management of the company's affairs. So mere lack of confidence is not enough. It says the lack of confidence has to emanate from the oppression of a minority by a majority in the management of the company affairs. Okay. This would apply to respondents also equally. The respondents cannot remove a person from the office of director merely saying that I have got lack of confidence on this person. I don't like him in the boardroom. Therefore, I am removing him. Okay. So he has to establish that. Okay. Then, and such oppression must involve at least an element of lack of probity or fair dealing to a member in the matter of his proprietary rights as a shareholder. So this is what I just want to say. Now, in a company, acts of oppression and mismanagement taken place, who can file this petition? So the old section is section 399 of the Companies Act 1956, and now the section 244, almost it is repeated except the waiver provision. Section 244 deals in two situations: the company having a share capital, company not having a share capital. In the case of a company having share capital, the qualification is prescribed in terms of number of members as well as in terms of issued capital. In terms of number of members, it says not less than 1/10 of the total number of members or not less than 100 members, whichever is less. In terms of issued capital, it says the members holding not less than 1/10 of the issued capital. So they can approach the NCLT for filing a petition under oppression mismanagement. Then in case of a company not having a share capital, not less than 1/5 of the total number of members, they can file a petition for oppression mismanagement. Under 244 section 1 proviso, it says the tribunal may waive all or any of the requirements. So this is what. And now, earlier under the 1956 Act, the Company Law Board in this petition, TNK Govindaraj Chetty and Company and others versus Kadri Mills CPE Limited and others, it has said where a shareholding of the petitioner is reduced below 10% due to further allotment of shares, and such allotment itself is questioned in the petition under section 397 and 398. If you don't question, then you are accepting the allotment. When you are accepting the allotment, then your shareholding is reduced below 10%. Then there becomes a necessity of taking waiver from the tribunal under section 244 1 proviso. But if you are challenging the very allotment itself or transfer of shares, okay, then the waiver requirement is need not be complied with. That is the decision of the CLB in this case. Under the old Act 1956, the waiver was required to be obtained from the central government. The power was with the central government. Now under the 2013 Act, the power has been vested with the NCLT. Therefore, the CLB has said when the shareholding is reduced below the 10% and the further allotment itself has been challenged in the petition, then the petition is maintainable. Now, under the old Act, the Karnataka High Court has also given a same decision. Vijayan, Rajesh and another versus MSP Plantations Private Limited. See, in this case, what has happened? The petitioner was having substantial shares, say 33% or 25%, I don't remember exactly. Then the entire shares, barring a few shares, were converted into preference shares, and those preference shares have been redeemed. And as a result of it, the petitioner's shareholding was reduced to nullity. The petition was filed before the Company Law Board. The Company Law Board upheld the conversion of the shares into equity and into preference shares, and the redemption of preference shares. Upheld those things. Those have been done in accordance with the provisions of the Companies Act 1956, and as a result, the petitioner did not qualify to file the petition. So that was not accepted by the Karnataka High Court in the appeal. In the appeal, Karnataka High Court said the Company Law Board has traversed in a reverse way. Okay, that is what the decision of the Karnataka High Court in this case. But in para 32, the Karnataka High Court specifically says, if the date of presentation of the petition, should be looked into a technical way, it could defeat the very purpose of the legislative enactment of section 397 and 398 of this act, as the overbearing majority shareholders can simply by high-handed action, or even for other purpose and by oppressive methods, dismember minority shareholders. So remove them from the company itself as member and leave with no remedies, as the dismembered minority shareholders technically do not qualify for filing a petition under section 399 of the Act, being not member at all, as the minority shareholders will be complaining only after the acts occurred, and when they have been removed from the membership of the company, the understanding and the interpretation to be given to section 399 is only so as to further the object of relief to be given in a situation governed by section 397, 398 of the Act, and not to foreclose the option to an aggrieved person and to deny the very relief sought to be extended to a complaining minority shareholders envisaged under section 397, 398 of the Act. I think this legal position has not changed even as on date. But as the case laws are reported, I feel this particular legal proposition already settled is sought to be disturbed now. Okay. Now, this is the another case, Worldwide Agencies Private Limited, and another versus Margaret D. Desar and others. In this case, what has happened? The member has deceased, but the deceased member name is still on the register of members. So the Supreme Court has said the legal representative of deceased member whose name is still on the register of members are entitled to file a petition. Okay. The other case is not relevant now. We'll see that. Now, the recent case law of Supreme Court has distinguished the judgment in Worldwide Agencies. In Worldwide Agencies, when this particular judgment was pronounced, there was no concept of appointing nominees for the shares. Okay. But under the Companies Act 1956, if my memory is right, during 2000, the concept of appointing nominee to the shares have been brought into, and it is now there part of section 72 of the Companies Act 2013 itself. In this case, what has happened? The Aruna Oswal versus Pankaj Oswal, the appellant, the original shareholder, has appointed some nominees for his shares, and subsequently he died also. Under section 72 of the Companies Act, unlike deposits and the insurance policies, when a nominee dies, when the original shareholder dies, the shares will vest in the nominee. Okay. In case of deposits, whereas in case of insurance policies, the nominee holds the amount as a trustee for the legal heirs of the deceased person. But 72 under the Companies Act is different. The shares itself will get vested in the hands of the nominee. So he will become the owner of the shares for all practical purposes. He will have the title and interest in the shares. In this case, what has happened? The shareholder has deceased. He nominated the some individual as his successor as nominee, and the appellant has filed a petition claiming that 1/4 of the shares belong to him. Therefore, he is entitled to file the petition and relied on the Worldwide Agencies judgment. And Supreme Court distinguished the judgment with these present facts before it. saying that here the shareholder has already given a nominated some person as nominee. Therefore, the nominee is for all practical purposes is the member of the company. You are not entitled to file the petition. Plus also the appellant has filed some civil suit claiming rights over the shares, claiming that he is the 1/4 of the shares of the deceased person have to come to him. Okay. And since you have already filed a civil suit also, you cannot maintain this petition. Let the civil suit be decided. After that, you can think about it. So that is the decision of the Supreme Court in this case law. So appointing a nominee will completely divest the rights of the legal representatives or legal heirs. If he has not been nominated, he will not be entitled to file the petition. So that is what. Now, the latest famous case law rendered under this Companies Act 2013 is Cyrus Investments Private Limited versus Tata Sons Limited. Okay. In this case, what has happened? The Cyrus missed his two companies, Cyrus Investments and another company, Sterling, another company. They held 18.37% of the issued equity share capital of the Tata Sons Limited, and including preference shares, the total shareholding was 2.17% of the issued share capital. Okay. In the petition filed before the NCLT, this was an admitted shareholding. The Cyrus Mystery or his companies did not challenge any of the allotment or any transfer of shares or oppressive act because there was no reason to do that. Okay, this position of this shareholding was there for a long time. Therefore, there was a necessity to ask for waiver of the requirements from 244. The Cyrus Investment, another company, has filed an application for waiving the requirements of section 244. NCLT dismissed it. Okay. Then matter went to NCLAT. NCLAT has upheld the NCLAT has the reversed the decision of the NCLT, and it said exceptional circumstances waiver has to be given. And while giving the decision, NCLAT also said the facts narrated in the petition, okay, so warrants intervention of the court in a tribunal, therefore exception has to be given. But subsequent decisions of the NCLAT in granting waiver, I have seen that the merits of the oppression and mismanagement shall not be gone into the while considering the waiver requirement. There are two decisions in case of professional courier. One, if my memory is correct, when Johnny George has filed a petition for waiver. In one company, waiver has been given by NCLT. In one company, waiver has not been given by the NCLT. The matter went to NCLAT. In the NCLAT has reversed the judgments of the NCLT. Where the waiver has been given, it has set aside. Where the waiver has not been given, it has allowed. Where the waiver has not been given, it has allowed. In those cases, it observed that none of the shareholders are having 10% of the share capital. They are having less than 10%. Therefore, this is an extraordinary situation. Okay. And the waiver has to be given. And in another case, it has observed two shareholders are having more than 10%. Okay. Therefore, the waiver given cannot be accepted. So that is the decision of the NCLAT. In another decision, the NCLAT also said only two of the shareholders are having some 20% or 30%. Rest of the shareholders are having very small number of shares. Therefore, this is an extraordinary situation that the waiver has to be given. Okay. But I have seen some petitions where the petitioner's shareholding has been reduced to below 10% due to further allotment of shares or due to transfer of shares. In those cases also, the people have gone and obtained a waiver. Okay. But in my view, such a waiver, filing of an waiver application is not necessary because of the decision of the CLB in TNK Govindaraj Chetty and Karnataka High Court in MSP Plantations Limited. That is why I said now the settled legal position is sought to be reversed now. Okay. Anyhow, let us see what happens in the future. Then, in this case, Tata Consultancy Services Cyrus Investments Limited, the NCLT has dismissed the petition of the Cyrus Mystery, that is through his two companies, Cyrus Investments and another company. And it has given a very elaborate order stating that whatever the allegations of oppressions have been made, and Mr. Cyrus Mystery was either party to those acts or those acts have happened with his knowledge, which means acquiescence. He cannot plead ignorance of the same. And some of the acts have happened even 10 years before. You cannot question that also. Okay. So that is the decision of the NCLT, and NCLT has dismissed the petition. The matter went to NCLAT. NCLAT did not give it findings on many of the allegations. It has given it findings on only 4 issues. One of the issues is removal of Mr. Cyrus Mystery from the office of the executive chairman. After the petition is filed, Mr. Cyrus Mystery was removed from the post of director, as well as the directors of various Tata groups of companies. Okay. And NCLAT has said the removal of Cyrus Mysteries from the office of the executive chairman is invalid, and also from other Tata group companies. In fact, those companies were not parties before the NCLT, and it reversed the decision of the NCLT. Then matter went to the Supreme Court. Supreme Court in this judgment only has elaborated how the oppression has come into, how the protection of the minority interest from the oppressive acts of the majority have come into English law over a period of time, and also in Indian law over a period of time. And it has stated in this decision that many of the facts, on many of the facts which the NCLT has negatived, that there is no oppression, NCLAT has not given its finding. Therefore, it is deemed that those findings have been accepted, because Supreme Court has said it is only a court for deciding the legal issues and not the facts. Not the dispute on the facts. Disputes on the facts, the NCLAT is the final authority. Okay. Then it also said the removal of office of executive chairman cannot be called an act of oppression. Insofar as the removal of the Cyrus Mystery from the office of director, he has been removed after the filing of the petition, because in the order it is seen that Mr. Cyrus Mystery has parted some information to the income tax department on various transactions. Okay, in turn, income tax department has questioned the Tata Sons Limited and others. So because of that, the Mr. Cyrus Mystery was removed from the office of director subsequent to the filing of the petition. Okay. In this case, what has happened also, the Tata Sons Limited was originally a private limited company. Under the Companies Act 1956, it became a deemed public company. Then during the pendency of the petition before the NCLT, if my memory is correct, the Tata Sons Limited has applied to the Register of Companies for changing its name in the certificate of incorporation. So what is important is it did not remove those 3 restrictive articles from its articles of association. In spite of becoming a deemed public company, it has retained those 3 conditions, that is limiting the number of members maximum to 50, then restriction on transfer of shares, then the prohibiting the issue of prospectus. Okay, so it was it has applied and got the word private added into the in certificate of incorporation. This was also set aside by the NCLAT, and Supreme Court has said in this particular case there is no actual conversion from public to private. The procedure laid down under section 14(1) need not be followed because it was always having those those 3 conditions in its articles. So what was required? Only a change in the certificate of incorporation. Then it upheld the action of the ROC as well as the action of the company getting the revised certificate of incorporation, and dismissed the petition of Mr. Cyrus Mystery in this case. Okay, and of course now I learned Mr. Cyrus Mystery has filed a review petition. That review petition may come up for hearing any time. Then there are 5 or 6 judgments of the Honorable Supreme Court which we have to go through to understand the oppression and mismanagement. One such a judgment is V.S. Krishnan and others versus Westfort High-Tech Hospital Limited. Then another judgment is Shankram Singh Gaikwad versus Shanti Devi Gaikwad. Then another judgment is Pratapan versus Dale and Carrington Private Limited. Okay. See this Pratapan versus Dale and Carrington Private Limited. In that, what has happened under the 1956 Act, an NRI was consistently sending money to the company, that Dale and Carrington Private Limited. The person who was in the management of the company, he was allotting shares to himself, though the money is sent by the another person. And the CLB has found that this is an act of oppression, but directed the NRI who has sent the money to sell the shares to the person who is managing the company. The matter went to the Kerala High Court. Kerala High Court has said the remedies was done the disease. Then matter went to the Supreme Court. Supreme Court in a way concurred with the Kerala High Court that this is nothing but an act of oppression only. Okay. In that case only, Supreme Court said under the 1956 Act, okay, though section 81 in case of rights issue it did not apply to a private limited company. It said it applies to private limited companies also. In that case, Supreme Court has said, okay. But subsequent to the V.K. Prathapan or D.K. Prathapan versus Dale and Carrington Private Limited, the judgment of Supreme Court, Shankram Singh Gaikwad versus Shanti Devi Gaikwad has come. In that judgment, the Supreme Court, Honorable Supreme Court has said, because under the 1956 Act, if you read some of the judgments under the winding up chapter, earlier judgment, you would be finding that the directors owe fiduciary duty to the shareholders. But this view has gone into this legal view has changed over a period of time. The Shankram Singh Gaikwad judgment, the Honorable Supreme Court has said the directors, they owe fiduciary duty only to the company and not to the shareholders. Okay. In case of exceptional circumstances, okay, the directors owe fiduciary duty to the shareholders also. It has illustrated 2 or 3 circumstances. One such circumstance is where the company is taken over under a friendly takeover. okay, not a hostile takeover and friendly takeover, the directors of the company have got a duty to the shareholders to say, fiduciary duty, whether the offer made by the acquirer is just, fair, equitable, etc. And in that also said, whenever a further issue of shares is also made, okay, then the directors have got a fiduciary duty to the shareholders. Okay. So in the Dale and Carrington judgment, the Supreme Court has said the provisions of Section 81 of 1956 Act will apply to the private limited companies also. But in this judgment, Shankram Singh Gaikwad judgment, the Honorable Supreme Court has said not under 81 applies or something. It said in case of certain, in certain circumstances, the directors have got a fiduciary duty to the shareholders also. One such circumstance is issue of further shares. Okay. Of course, now under Section 62 of the Companies Act 2013, it does not differentiate between private limited company and public limited company, unlike Section 81 of the old Act. In case of private limited company also, the further shares have to be offered to the existing shareholders also. In this judgment, V.S. Krishnan and others versus Westport High-Tech Hospital Limited and others, the Honorable Supreme Court has dealt with the doctrine of legitimate expectation. So in this case, the petitioners have made a submission before the CLB and also before the High Court. Okay. When they became the shareholders, they always had a legitimate expectation. They would always be part of the board. Okay. And you can be part of the board provided you enjoy the majority. That's a different matter. Okay. But Supreme Court in this case law dealt with the legitimate expectation and ultimately said your legitimate expectation should be within four corners of the company law. It cannot traverse beyond that. So this is the another judgment of the Supreme Court. Okay. So we have to be, once we read these judgments, we'll be understanding the oppression. Okay. Then another judgment of the Supreme Court is Needle Industries Private Limited versus Needle Industries New Wave Holdings Limited. That also exhaustively deals with the oppression. In that case, the Honorable Supreme Court has said, okay, an act may be perfectly legal, but yet it can be oppressive. Okay. An act which is perfectly legal, it is oppressive, and vice versa also. Okay. And an act which is totally illegal may not be oppressive also. For example, take a case. I'm telling you an hypothetical situation. Two persons incorporate a company for smuggling goods and selling the goods. Okay, of course, in the object class, if you have it specifically, ROC will not incorporate. That's a different matter. Okay, but they smuggle the goods, sell the goods inside the country. Okay, and share the proceeds equally. Okay, there is an equal understanding. What they do is perfectly fits into illegal business. Okay, but yet you can say that there is no oppression. So that is what an act which is perfectly legal may be an oppressive act. Okay, an act which is totally illegal may not be an oppressive act. Okay. In the old act, in the case of Ruby General Hospital Limited, the company law board has given a decision. Okay, you know that in the case of a director, the notice of the meeting under the old act has to be delivered to his registered address in India. In that particular case, the petitioner, who is a doctor, was always residing in abroad. Maybe if my memory is right, in UK. Okay. The management, the people who were in the management, they were delivering the notices for board meeting in his registered address in India, and without his presence, they have conducted the board meeting. Certain decisions have been taken. Those decisions have been challenged by the doctor who resided in UK. And the persons who were in the management of the company, they were having the knowledge that this person always resides in UK only, not in the address in India, which is registered with the company. Okay. The company law board has said, okay, the serving of a notice to a director to his registered address in India, okay, is perfectly legal as per the Companies Act. But yet it is oppressive because the respondents were having the knowledge that he was not in the country, he was always residing in UK. So this is the judgment of the company law board. Okay. So this judgment of the company law board, Needle Industries case, will throw light what is an act of oppression. An illegal act may not be an oppressive act. An act which is perfectly legal may yet be oppressive also. This one. Then the application of partnership principles. Okay. In many cases, before the NCLT or the CLB, the people have advanced the theory that this company is incorporated, though under the Companies Act, is run on the principles of partnership. Okay. Therefore, the mutual trust and confidence, which is the essence of the partnership, will apply to the company. Okay. But in this case, the Honorable Supreme Court has said, okay, Kilpus Private Limited and others versus Shekhar Mehra, the Honorable Supreme Court has said the invoking of partnership principles to an incorporated company should not be easily accepted, because you have come to an understanding that this company should be incorporated in the Companies Act. This company should be run on the laws and principles laid down by the Companies Act. That principle of quasi-partnership should not be easily accepted. Okay. But CLB subsequently and the Supreme Court also has given certain decisions where the companies run on the principles of partnership has been accepted. One such a case is where a partnership firm is converted into a company under the Part 9 of the Companies Act or under the relevant chapter of the present Companies Act 2013. So naturally, when a company is partnership is converted into a company, so it goes without saying that this company is basically a partnership concern. Okay. Then how the shares are distributed among the members of the company right from the beginning, whether there is some kind of a proportion. Okay. Though rights issue also there in the existing manner, it should be in the existing shares held, it should be offered. Okay. Then participation in the management. Okay. Whether one group is always participating and another group is not participating, etc., etc. All these things were taken into consideration to decide whether the company is run on the principles of partnership. Okay. One such a case where the CLB has denied that this company is run on the principles of partnership is that the articles of a company contained a clause that the directors need not have qualification shares. Okay. The CLB has said, okay, when the articles of a company says the directors need not have qualification shares, okay, it said how the principle of quasi-partnership or how the principle of proportional representation can be fit into this company. Okay. Especially the petitioners have not challenged that particular article. Okay. They have not challenged that particular article. So the intention of having an article that directors need not have qualification shares itself exhibits, okay, that any outsider, any Tom, Dick and Harry can be brought into the board without having a share. Okay. But the system of proportional representation requires, okay, that person, in order to come into the board, he should have some percentage of the shares. Okay. So this article not having any qualification shares, okay, and the proportional representation and the quasi-partnership do not go together. So that is the decision of the CLB in one case. I am not remembering that particular case law now. Okay. The issue of further shares, a single act, whether oppressive. Okay. So in this case, the Calcutta High Court has said T Brokers Private Limited versus Hemendra Prasad Barua. A single act, though it is a single act, its effect is continuous. Okay. And because of that, it is an act of oppression. But this particular position may not hold good under the present Companies Act. Okay, because if it is a single act, you will have to challenge it within a period of 3 years, within a period of 3 years of the date of the allotment. Or alternatively, under section 17 of the Limitation Act, okay, if any fraud or mistake has happened, okay, the period of limitation will run from the date of the knowledge of the fraud or from the date of the knowledge of the mistake as happened in the company. So under the present situation, the person who approaches the NCLT has to prove before the NCLT, though the allotment has taken place 5 years or 4 years, that is beyond the period of limitation, I have come to know the allotment now only, that is within the period of limitation, 3 years of the within 3 years prior to the filing of the petition. And if he is able to satisfy section 17 of the Limitation Act, then the petition is maintainable. Okay. One such reason could be where the company has allotted the shares, but has not filed the form PS3 deliberately. Okay. And it has filed the form PS3 belatedly. Okay. Then incidentally, if filing of form PS3 falls within the period of limitation, that is within 3 years prior to the filing of the petition, then there is every chance of accepting the petition. Okay. Otherwise, under the present dispensation, a single allotment of shares, okay, may not hold good for filing a petition under the section 241. Then transfer of shares in violation of articles, okay, A. Arumugam and others versus Pioneer Bakeries Private Limited and others, and V. Ramesh Kumar and others, 141 company cases. The company law board said, no member shall be entitled to transfer his shares in the company, save with the previous sanction of the board of directors. No shares shall be transferred to non-member as long as any member is willing to purchase some at a mutually agreeable value between the transferor and the transferee. In this case, the transfer of shares have happened in violation of the articles. Okay. Therefore, the company law board has said in these cases that the transfer of shares is an act of oppression. So this is what the company law board has said, and negative would be transfer of shares. Okay. And I will switch over to some other slide, and sorry for this decision just unequitable to winding up whether compulsory. Okay. This Hanuman Prasad Bagri versus Bagri Cereals Private Limited, this case has been relied by the Honorable Supreme Court in this Cyrus Mystery case also. Okay. This Hanuman Prasad Bagri versus Bagri Cereals, the Calcutta High Court has said, because the old section 397, 398 and 241, both the section gives power to the adjudicating authority to make such orders to put an end to the matters complained of, Okay. So in this Bagri Cereals Private Limited, what has happened? The Calcutta High Court has said the acts of oppression have not been proved. Therefore, it simply dismissed the petition. The matter went to the Supreme Court. In that case, the Honorable Supreme Court has observed, because there are quite a number of shareholders, okay. Then the petitioner's shareholding was somewhat 20% only, okay. Then the Supreme Court has observed, even for a special resolution, the assistance of the petitioner is not required, okay. Therefore, there is no need to direct the respondent company to purchase the shares of the petitioner. Okay. Normally, in a case of oppression mismanagement, the CLB or the NCLT invariably directs the respondent, most of the time directs the majority shareholder to purchase the shares of the minority shareholder, because that only put an end to the matters complained of, because petitioner and the respondent do not see eye to eye. Their continuance in the company is not good for the company. Okay, it is not in the best interest of the company. So CLB and NCLT in most of the cases direct the petitioner to sell the shares to the respondent, majority respondents. In one or two instances, exceptions, it has directed the majority shareholder to sell it to minority shareholders also. Exceptional circumstances are there. Okay. But in this case, what has happened, Hanuman Prasad Bagri versus Bagri Cereals Private Limited, the Calcutta High Court said there is no act of oppression has been proved out. Okay. Therefore, the petitioner is not entitled to any relief and dismiss the petition. Okay. The matter went before the Supreme Court. The Honorable Supreme Court has upheld the decision of the Calcutta High Court. While upholding the decision of the Calcutta High Court, it said because the petitioner is having only 20% of the share capital, he cannot even, the company can be run, the majority shareholders even pass a special resolution without the assistance of the petitioner. Okay. And since the petitioner has not proved any act of oppression, okay, the petition is liable to be dismissed. In fact, an argument was advanced before the Supreme Court to direct the company to purchase the shares of the petitioner, okay, or respondents. Okay, the Supreme Court refused to recognize this. But coming into this last case, MSD Radharaman versus MSD Chandrasekhar Raja and others, there are only two shareholders. This case gone to Supreme Court arising out of the orders of the company law board. Okay. Father and son are the shareholders, only two shareholders. Okay. The company law board found that no act of oppression has been made out. Okay. But directed one of the party to purchase the shares of the other party, as because there is only two shareholders. Okay. So here there was a necessity to put an end to the matters complained of. Such an order is required to be passed. And matter went to the Madras High Court. The Madras High Court has upheld the order. Then matter went to Supreme Court. Supreme Court has also upheld the order of the CLB. So this is what the we have to see here. Then mismanagement is prejudicial to the interests of the members of the company and public interest. And in the English Act uses the word unfairly prejudicial. In our Act, the unfairly prejudicial is not used. It now uses the word prejudicial to the interests of the members, or prejudicial to the interests of the company, or oppressive to the members. Okay. Then company has not been made respondent whether petition is liable to be dismissed. In this case, company law board has dismissed the petition of the petitioners because the company has not been made respondent. The company may be a pro forma respondent, yet it has to be made a respondent. Then whether company can be a petitioner, okay, in case of oppression mismanagement, it cannot be, because oppression, after all, it is done by one section of shareholders committed towards another section of shareholders. Okay, mismanagement is also the persons who are in charge of the management of the company. They are doing mismanagement. Okay. Therefore, in this case, the company law board said the company cannot be a petitioner. The company can only be a pro forma respondent. Then, so these are all the so now the decisions have come before rendered by NCLAT. Okay. In this case, the Honorable Supreme Court has said conduction of board meeting without notice to the director is an act of oppression. Okay. Now, before the NCLAT, in certain cases, I have seen that the respondents have always argued we have filed the balance sheet, that is financial statements, annual returns within time with the ROC. Okay, assuming that we have not given notice to the petitioners. Okay, it is a public document. In the annual return and the financial statement, date of AGM, everything has been indicated. Okay, therefore the petitioner has not raised earlier all these things. Okay, and the petitioner accuses the fact this should be dismissed and also barred by limitation. And fortunately, under the NCLAT, now these decisions have become very clear. Okay, NCLAT has said in 2 cases, if my memory is right, this company has got a duty to give notice to the shareholders for conducting the AGM and also for sending the financial statements to the shareholders of the company. Okay, it is a primary responsibility of the company. Company, without complying with those things, it cannot rely on the documents filed with the ROC to say that they have not committed oppression. So this is now made very clear. Okay, in case of a shareholder, the financial statements and annual returns, though once it is filed with the ROC, it becomes a public document. Yet only for a shareholder member, the Companies Act makes it obligatory that the directors have to, that the company has to send a notice of the AGM and serve a copy of the financial statements. Okay, so the NCLAT relying on this, and you cannot rely on the public documents filed with the ROC. It is primary responsibility that you have to prove that you have served the notices on the petitioner, and held wherever it has not been done, it is an act of oppression. Okay, so in this case also, Cobin Private Limited, Cobin India Private Limited, there was further issue of shares to the exclusion of the minority, but that was the only act. Okay, in this case, Company Law Board has said, though it is a only act, further issue of shares, the effect is continuous, and because of that it will fall under oppression. Okay, but now that may not be hold good. Okay, now the person who want to challenge the further issue of shares from the allotment of shares, he has to challenge it before the expiry of 3 years, or from the date of knowledge, 3 years within 3 years from the date of knowledge of the further allotment of shares. So these are all the acts of oppression and mismanagement. So with this, I conclude my lecture. Thank you.
Thank you very much, sir, for the wonderful presentation. Hope the members would have been benefited from this session today. Thank you very much. There are 1 or 2 queries in the chat box.
Yes, yes.
Yeah. If time permits, we will see that, sir. We have some time.
Sir, actually, in these corporate law areas, we hardly deal in these kind of aspects. So it was really a very good insight for all of us in these areas. It becomes more challenging when we see some notices from ROC where the NCLT cases are there. So it's really a good insight for us to know how to handle these events. There are some questions like how to develop a case in respect of operation and mismanagement in case of
see, filing an oppression mismanagement case is a strategy actually. Okay, it is like preparing for a war, not a battle also. Okay, it's like preparing for a war. Okay, so the moment the management of the company indulges in some acts of oppression and mismanagement, okay, the person who is affected, he has to correspond with the company, okay, management, who are in the management, and create records. So because the proceedings before NCLT and the proceedings before Company Law Board are basically summary proceedings. Okay, though NCLT rules speaks about taking of witnesses, chief examination, cross-examination, it has not been done due to the paucity of time. Okay, and NCLT time and again in its order it has said it is only a summary proceedings. Okay, in summary proceedings, the documents plays a vital role. The document plays a vital role. Therefore, you will have to not create the documents, construct the documents. So whenever some acts of oppression mismanagement takes place, issue letters to the company or email to the company and get replies. Okay. And if the no reply is given, then it is a deemed acceptance. Okay. And you will have to link the events. Okay. For example, take in one of my case, I don't want to say the name of the company. Okay. The particular person was in charge of the management of the company. Okay. Has evaded service tax. During that particular time, he has pumped in a lot of money into the company. Okay, the money has come into his ledger account, okay, and got deposited into the banking account of the company. Okay, during the same time only, the petitioner's shares were transferred to that particular respondent without the knowledge of the petitioner. Okay, and he has created records that he has paid so much money of cash to the petitioner. Okay, the cash is nothing but it is not a small amount, it is nearly 1.50 crores. So on various dates, 20 lakhs have been given like that, 30 lakhs have been given, 15 lakhs have been given like that. That too by a entry in his ledger account. Okay, so you will have to relate it. First of all, nobody will give 20 lakh, 30 lakhs cash. Okay, it has to be done by banking channels only. Okay, then when he says that I have given a cash, okay, that he must have at least given some email to the respondent, that petitioner on transferring the cash. Today I have transferred so much money to your account in settlement of the consideration for shares. Okay, because the money has been transferred over 7 or 8 days. Okay, 7 or 8 different dates. Okay, so on different dates, whenever you are transferred, you should have issued an email. Okay, or the petitioner should have authorized the respondent, you transfer this money to this particular account. Okay, whenever you make the consideration, there is no mail or correspondence from the petitioner to the respondent, nor there is no mail or correspondence from the respondent to the petitioner on so and so date, I have transferred the money. Okay, and moreover, during this particular time only, he has evaded the service tax. Okay, service tax department subsequently filed a prosecution also. Okay, that charge sheet has also been somehow landed in the hands of the petitioner. So kindly see, he has received so much, evaded so much money, service tax during this particular period. Okay, this money has deposited into the company. Okay, and that money he wanted to project it as a share consideration. Okay, so in the operational mismanagement, you will have to link the events. Then only you will be successful. If you argue the events separately, okay, then you may not be successful.
Got it, sir. Thank you.
Right. We now call upon CA Bharati to present vote of thanks. CA Bharati.
Good evening, all. So today's concept, oppression and management, since this is a very confusing and complicated topic or area for so many people, including myself also. So when we are going to take up these kind of problems in a company, then we'll have a confusion where to start and how to move and how to make a petition. Everything will have some confusions. Sir has given a very brief and sweet, what to say, in a calm manner and cool manner. So everything using a case laws. Actually, when you take up a case law, reading that and understanding and coming to a conclusion is taking so much of the time. But Sir has given all the case laws and quoted so many case laws, nearly 25 to 30 case laws he has quoted. Starting from Devas Multimedia Private Limited, etc., and ending with even I can remember this Bharati Cotton Mills. Maybe that may be in my name. I'm remembering very well. So all this case laws he has quoted in a very great manner. So, and I also have an idea how can we remember or quote some case laws. So this is explained in a very great manner. And the next one, when we go to this judgments and deciding or understanding this judgment is a very big area. So Sridharan sir has explained all this in a nice manner. Thank you, sir. Thank you so much on behalf of our colleagues or my friends. Thank you so much, Sridharan sir.
Thank you. Thank you.
Thank you,
Thank you,
sir.
Bharat.
Thank you.
Thank you all for listening.
Thank you. Thank you, sir.
Thank you, sir.
We'll surely call you once for a physical program in our branch. Thank
Sure.
you.
Thank you.
Thank you.
Thank you.
Friends, we now move on to the next session. Really weighted session for all of us. I'm really excited here to welcome our Sri Priya Madam, CCM. Over to Geeta Madam.
Good evening, members. Respected CCM and ICA Corporate Law Committee Chairperson Sri Priya Kumar Madam, Chairman of the branch, and esteemed members, ladies and gentlemen, a warm evening to everyone present here. And now we are going to hear from Sri Priya Madam
On
on
key safeguards.
key safeguards in audit reporting.
I request CA Srinivasan, please welcome our madam today.
A very good afternoon to all delegates who have joined this online session. And today's topic is key safeguards in audit reporting. And the speaker of the day is our well-known Central Council member, Sri Priya Kumar, and I have the opportunity of introducing her today. Introducing someone like Sri Priya Madam is like introducing a sky or the sun, because she is such a well-known, familiar face to all of us. I thank the Chengalpattu branch SARC of ICI and the committee members for giving me the privilege of introducing this elite speaker. Madam Sri Priya Kumar qualified as Chartered Accountant in 1996, and she has worked with companies like Ford India and PwC, and she commenced her practice in 2001. As we all know, she is the present Central Council member of the Institute of Chartered Accountants of India for the term 2022 to 25. Earlier, she has been Central Council member for the period 2016 to 2019, and also she served in SARC during 2012 to 2015. She is presently the chairperson in the Corporate Laws and Governance Committee and the Women Members Committee. She is also the vice chairperson of the Insolvency Laws Committee. Also, she is the member of the Disciplinary Committee for the Northern Region and a member of many other committees. In her earlier tenure as CCM, she has served as the chairperson of the Continuing Professional Education Committee and was also the vice chairperson of the Peer Review Board. She had also served on the Executive Committee, Examination Committee, and the Management Committee of the ICI. She is the convener of the Insolvency and Bankruptcy Laws Group of the ICI. She had been appointed to the working group constituted by the Ministry of Corporate Affairs for drafting the rules and regulations of the Bankruptcy and Insolvency Code. MCA is presently upgrading and migrating LLP e-filing services to MCA V3 portal. Madam Sri Priya Kumar is actively engaged in this project to make it smooth and successful. She is a regular faculty on training programs of the ICAI and other accredited institutions and has delivered numerous lectures. Her commitment to the profession and her compassion to the fellow professionals can be seen from the Smart CA initiative that she took when the New Companies Act 2013 was introduced. All of us have been enriched by the useful inputs through her mails, templates, etc., and the knowledge that she shared. As a truly committed professional, in spite of her busy schedule and personal commitments, she is here today with us to share her thoughts on today's topic, key safeguards in audit reporting. Over to the one and only Madam Sri Priya Kumar. Thank you.
Namaskaram, and thank you very, very much. There's something about Chengalpattu branch, so it feels like family. It feels all the more like family today because Bharati is my mother's name and Srinivasan is my brother's name. And I have another namesake, which is Priya. So thank you so much, and very, very well summarized by Bharati. And when somebody speaks like that from the heart, you know that the CPE has actually delivered its intended purpose and not just, a theoretical session that's happened. And kudos to Sridharan sir also for this very nice presentation. And more importantly, for having rescheduled our timings. I was supposed to speak first. So thank you, Sridharan sir. So without much ado, let's move straight into the topic of the day, which is audit reporting. Is my PowerPoint presentation visible, Priya?
Yes, ma'am. Yeah. So we're going to talk about safeguards, key safeguards in audit reporting. Now, what's different about audit reporting of 21-22? That all of us are actually, once again, in fact, it's been back to the basics, even with the ICAI Central Council. There's been a huge change in this landscape. More importantly, a huge change in perception of what the audit profession is supposed to do, which is why I think today it's very, very important to go back to the drawing board and look at our roles as auditors and to look at the key safeguards that we need to have in the audit reporting process. There have been many, many changes that have been happening in the last 2 years. You've got a new CARO, you've got a new Schedule 3, you've got enhancements to auditors' rules, you've had enhancements to accounts rules. Now, all this dramatically sort of changes the landscape, but very importantly, seems to reiterate the principles of Companies Act 2013. And what are these principles? ACT. Your Companies Act here is not a noun, it's actually a set of adjectives. It's accountability, corporate governance, and transparency. Before I actually move to my subject, in the last couple of months, I have seen a huge amount of proceedings being initiated against auditors. The MCA has sent out many, many notices on Chinese companies. They've been sent to auditors who are actually auditing good companies, big companies with infrastructure, but nevertheless labeled or alleged to be shell. FIRs have been filed. It's been a very, very difficult environment for auditors to operate in. And I think a very interesting thing that I want to talk about is perception. See, unfortunately, we are a qualitative profession. Why do I say qualitative? Because you present an opinion. Now, whenever there is a qualitative aspect to a profession, or most professions are qualitative actually, whether it's a doctor doing a diagnosis or a chartered accountant reporting true and fair, there's a lot of perception gap that happens. There is a huge expectation gap. What was the auditing profession supposed to do? We were created way back in 1949. Honestly, we haven't changed much from there. We said we have to present true and fair opinion on the financial statements. Now, are we actually doing it correctly is one question. That's a gap. Today, if you look at IBC, that's perhaps been the biggest game changer, not in favor of our profession. There have been lots of corporate failures. There are repeated questions on whether auditors could have done better. So that's one expectation gap. What we were made out to do to what we have delivered. That's easy to manage because we've got standards, we're going to do these repeat training programs, etc., etc. So we'll manage that expectation gap. But the second is a larger gap. What an auditor thinks he should do or she should do versus what the market thinks you're doing. Today, you find that there has been a countrywide institutional failure in many, many cases. You had SEBI in the context of NASC. There have been talking about failures of us as a regulator. So I think all the credit rating as an institution. So all of us are institutions. Today, I'm an auditor, I'm an institution. You're an institution. So these institutional failures, have sharpened the focus on why an auditor has failed or what should have the auditor done better. So it's in this context. See, you can't be in a well and say, this is all I will do. Unfortunately, this Kingston cotton mill, etc., has undergone a complete transformation. So much so, when I see a new CLC report that's come,
please go to the CLC report and see how they have defined auditing. They have defined auditing and quoted the Ramaya, the Companies Act by Ramaya, saying audit is instrumental in preventing frauds and errors. I mean, I really don't think so, but that's the perception today. So it's in this context that this entire issue of audit reporting assumes a lot of significance. I had two choices before me today. One, I could have made an outright theoretical presentation, starting from the standards on auditing, going down, reading it line by verse, and saying, okay, this is how you should do. I could have read out 143 for you. We could have spoken about it. But I've chosen to do something different. At the end of this program, I'd like to just sort of, if I may use the term, transfer whatever I think in some perspective of what I would do as an auditor, or more importantly, as a regulator. Let's say tomorrow the accounts that you've done goes to a banker and there is an issue. Am I safe? And that's the context in which I have done this entire presentation on safeguards in audit reporting. And just like a garland of very, very diverse flowers, I've not really done this in any, structured, logical manner, but I'm just going to present about 50, 60 views in the next maybe 45 minutes. Lots of things that you already know, which we've studied right from our inter, final, etc., etc. The first concept I come to is independence. And again, these are somewhat based on common failures that we have come across in the past. CAs we know, disciplinary issues, etc., etc. So the first thing that I'd like to talk about is a joint stock company. So why do you need an audit? You need an audit because you're in a joint stock company, your ownership is different from the management. So if my ownership and management are the same, then your audit risk is somewhat lesser. Meaning if your directors and shareholders are the same. But today what happens, two directors have a fight and then go and file a complaint in ICI, file a police complaint. So today, nothing is no risk in our profession, which is why the first thing is this concept of independence. The Companies Act lays down the independence norms for an auditor in terms of shareholding, in terms of indebtedness, etc. So that's the first important aspect. An auditor has to be independent of an entity. Again, you may ask me, now there is one more aspect of independence, which is section 144 of the Companies Act. It says you must not render these services to a client. Today you will have a gray area. You'll say, oh, management service is there. Can I do it? In such circumstances, who is the best judge? Yourself. You must be convinced that there is no independence threat, self-review threat, advocacy threat, intimidation threat, or a familiarity threat. If these threats are there, please don't accept the audit engagement or you resign from what is the other service. Now, where does all this audit? And today when we're talking about audit reporting and safeguards, and since this is organized by the Corporate Laws Committee here, I presume we're talking about audit of companies, but it's absolutely generic. Where do I get my right or my duty to audit? It comes from a section in the Companies Act that says every company shall, at the annual general body meeting, place its audited financial statements. From thereafter, it comes to section 143, which talks about the powers and duties of an auditor. Please, this year, before you start your company audits, start with 143. You have revised accounts rules. So the Companies Act is a delegated legislation. You have a body of law, and then you have rules as may be prescribed. So you have directors' rules, you have CSR rules, you have accounts rules, you have audit rules, etc. So there is a revision in the accounts rules. Similarly, there's a revision in the audit and auditors' rules. Certain additional paragraphs have been incorporated for auditors' reporting. You remember there is a clause in the auditor's report where you talk of IEPF and you would talk about material litigation. To that paragraph, there is a change. There is a revised CARO today. Again, I'm taking a lot of care to make sure that I'm not going to talk too much about Caro and Schedule 3 because these are two independent sessions by themselves. And it would extend my session to too long. There's a revised Schedule 3. I think the additional information in paragraph K is as big as the Schedule 3 itself. There is so much of enhanced reporting requirements. You're required to certify the ICOFR, the internal controls over financial reporting. My client is in Tally. No controls over addition, deletion of vouchers. Is it a bad ICOFR? Should I say nothing is fine? No. You're expected to perform additional audit procedures to convince yourself that your internal controls are functioning effectively. How do I present my audit report? The SA 700 series. Meticulous compliance. Word-to-word compliance is mandated. Accounting standards, auditing standards, section 143 also says it shall be our responsibility to ensure that your accounting and auditing standards are complied with. So I spoke about some changes, right? What are these changes? These are very important because normally what we tend to do is we'll take whatever is there in the previous year and we will change the years, etc. and prepare it. All of us do the same thing, but please remember, only for, there is a revised Schedule 3, revised Caro, many changes for reporting of 21-22. There's a change in the accounts rules. It talks about compulsory audit trails. This particular provision alone has been deferred to next year. Disclosure by the management of any application or proceeding under IBC. Valuation of assets during availment of a loan versus valuation during OTS. See, there's one thing about this government that I'm completely appreciative about. The moment they see a problem, they try and fix it. Now, the changes that you see in Caro and Schedule 3, I mean, nobody likes to change a law, right? Why would, in fact, I heard this in some seminar. Companies Act 1956 apparently had only 24 amendments or something like that. This act has about an average of 24 amendments in every amendment stage. And now you got another massive set of amendments coming in if the recommendations of the Corporate Law Committee report are going to be adopted by this government. Why did this valuation become very important? Promoter takes 200 crores from a bank. Valuation report is at a grand 250 crores. OTS 30 crores. What is the value of assets during 30 crores? If it's 200 crores, the bank shouldn't be doing it, right? The bank should recover the asset, or suddenly you find that the valuer who has given 250 crores, there is some other valuer who's saying only 20 crores. In which case it was a fraudulent valuation report in the first stage. The government is interested today in all this. Change in audit rules. So we previously had the specified banknotes disclosure in the year of demonetization. That is now omitted. Two very interesting inclusions that I will talk about if I have the time. Otherwise, it would be well covered both in Caro and in Schedule 3. Changes. Funds received for an ultimate beneficiary. I am company B. And when I say I'm talking about the auditor of a company or the company itself. I am company B. I have received funds from somebody else. I need to report. Where the benefit of this fund movement has gone to A. The second is, I am A. I have given money to B. B has given money to C. C has given money to D. But all for the benefit of A. I have to report that. Compliance with section 123, again, is an inclusion paragraph. So this year, in addition to your points on pending litigation, IEPF, etc., you will be having 3 additional clauses and 1 reduction, which is a specified banknote. Accounting trails for audit software, rescheduled to next year. So now let's go to what's overall safeguards. Some of these could be slightly repeated, but I'm going to wrap this up in about 25 minutes. And we'll quickly go to Schedule 3 and Karo and see what are the most important things where we are likely to slip. Appreciation of audit risk and expectation. What is the only way? What is audit risk? It is the risk of an auditor that he has certified a financial statement without understanding and reporting the material misstatement. It's a very small, easy way of understanding it. That's my risk as an auditor. That I have failed to cognize for a material misstatement, whether due to fraud or error. Very interestingly, if you go look at NAFRA website, they've presented reports on large companies. But I found it extremely surprising that they had picked a company called KIOCL, Kudremukh Iron Ore Company. I don't remember the exact name, but I think that's what it is. I don't remember the first name, but they said the auditor, the management has not given the SOCI, the statement of changes in equity, which is mandatory. So please remember, financial statements must include balance sheet, P&L, cash flow statement, SOCI, and notes. SOCI is for the Ind AS, I mean, the compliance there. Cash flow, of course, there is an exemption for certain categories of companies where it says who all OPC, dormant, etc. don't have to do a cash flow statement. It's there in section 2, the definition section. Now, I always find it very interesting to do the cash flow, even if I'm not going to sign a report. And incidentally, I don't do much audits, but whatever clients I have looked at, I've always tried to prepare a cash flow because it gives you far more insights than your balance sheet and P&L. The third thing, financial statements should be as per Schedule 3. It's a sine qua non. What does that mean? It means it's a given. You can't change. So if Schedule 3 says crores, rupees, rounding, you have to go through your Schedule 3, start from the beginning till the end. It has to be in that format only. If a particular item is not there, you're not going to give it. Audit report only in SA 700 series, including new Caro and new Caro. Now, one interesting thing, what is true and fair? It means only two things, much as the world believes it to be a lot of other things. One, that my financial statements have been prepared in accordance with an applicable reporting framework, which is Schedule 3. And two, my financial statements are free from material misstatements, whether due to fraud or error. This is what true and fair means. Now, accounting standards to be complied, because 143 says you have to comply. Auditing standards are also referred to in 143. Most important, your directors are not to be disqualified. That's also there in 143. You're going to talk about impact of pending litigation in your audit report. Very, very important. Now, you may say, my client, so first safeguard, please get a representation. I have seen many, many cases where the company has already been dragged to DRT by the banker, but the auditor didn't know about it. So a management representation is key. Now, as we speak, Institute is trying to tie up with the service provider to provide additional visibility to MCA data. There are external service providers who also give you details of pending litigation, which you can get for as low as 300 to 500 rupees. You'll be able to access these websites. They give you cases filed by the company, cases filed against the company. What is the forum, whether it is NCLT, DRT, subjudicial magistrate, what is the case number and what is the status of the case? What more do you want? Only private arbitrations may not feature in such reports. Compliance with dividend provisions, funds reporting as an intermediary or a parent, which I spoke to you, application or proceeding under IBC, valuation difference between loan availment report and OTS report, the valuation report. Another thing that's a big one is transactions with strike-off companies. See, much as it makes my life difficult as an auditor, I think MCA coming up with this change of transactions with strike-off companies is a huge one. And I would attribute it as a very key IBC learning. Funds move from company A to company B to company C to company D, and it's all struck off. See, I mean, till 2012, share premiums of closely held companies were not taxable. So many companies got created. See, if there was a huge amount of cash bribe somewhere happening, let's say 100 crores, how would they bring it back into a mainstream? It's something called as layering, placement, etc. So first, I will take the 100 crores, break it into 100, give cash of 1 crore to 100 people, make them come as shareholders in the company. And today, where are those shareholders? They won't even be there. And just in the east of India, if you look at the public domain, there is one shell company, 17,000 that you will find. 80% are there in the east of India. And some of them, you know, what's typical of a shell companies, you will find 500 shell companies in one address, one MCA address, one mail ID. I think this is a good development. Audit report to be in the 700 series. Going concern qualification. This is something we have to be very careful about. If your accumulated losses have close to or exceeding your net worth, you need to go back, you need to understand whether this particular legal entity can continue as a going concern in the future. And there's a standard of audit for that. I'll come to fraud reporting slightly later. That's under 143.12. Scope limitation. Many a time your client tells me, I've not got this. Oh, I don't have this paper. Now, what's very important is you tell your article assistant to vouch 200 transactions. The client will give you only 150. Your article assistant doesn't have to come and tell you I got 150. She has to come back and tell you I didn't get 50. That's very important. Reporting on loans and advances, transactions which are prejudicial to the interests of the company. These are all your 143.1 inquiries. Very important. And if you look at it, this 143 inquiry, one inquiry comes right at the beginning. It comes in 143 itself. It has a higher privilege, in my opinion, than most other things. So if there's a problem, somebody would first go to 143. Transactions must not be mere book entries. I've seen companies where you have 600 crores, 700 crores of journal vouchers which are passed. Today, if you debit company A and credit your company 40 crores, should that transaction not have a backup? Why is that transaction entry getting passed? Please look at all journal vouchers. What's a high-risk transaction today? A high-risk transaction is a transaction which impacts 2 GL accounts. See, it's very difficult to do a customer fraud because somewhere along the line, there is a third-party confirmation. But if you pass an entry between 2 GL accounts, which is what is called as a journal voucher, you have to be very careful, and they are your book entries. So bad debts to P&L, classic case. It's 2 GL entries, right? Sale of securities less than purchase value if it's not a banking or a financial services company. Loans and advances shown as deposits. Personal expenses charged to revenue. Cash received. Cash must be received when shares are allotted for cash. Many returns of allotment stated as for cash, but cash has not been received. Now, especially, see again, today, what are we looking at? We have 4 crore cases pending in courts across India, according to the Chief Justice today. We have 10 trillion worth of debt sitting in BRT. Why? What happened? So when a promoter says, I'll bring in contribution, he'll bring it from a group company, one group company entry. Group company X to equity share capital. So banker thinks the money has come. Return of allotment also has gone as cash. Please be a little careful. Proper books of accounts must be maintained. Here, I would like to place additional emphasis on inventories. A lot of clients don't charge consumption entries, etc. Inventory consumption is actually a closing balance. Opening balance plus purchases minus closing stock is equal to consumption. Please be very careful. Balance sheet and P&L must be in agreement with the books of accounts and returns. So that final version of your trial balance, please ensure you have it. You need to comment on matters which have an adverse impact on the functioning of the company. Correct? You have your emphasis of matters paragraph, basis of qualified opinion paragraph. Now today, when you're qualifying something, you must have quantification of impact. The standard says where practicable. But today, again, I'm seeing a huge change in the spectrum. The Corporate Laws Committee report has spoken about audit report qualifications. And this Corporate Laws Committee report now, which has come in, runs to many, many pages. It says you must give a qualification statement to the board and to the shareholders. If you look at listed companies, SEBI has a format of qualification. So today, you can't sort of slide. You have to be, it's a yes or a no. Now, again, let me tell you one thing that's very, very important from an audit reporting perspective. Number one, you need to quantify your qualification. A company has become an NPA. The bank will stop accruing the interest in their books. It will only be maintained as a memorandum interest. Our client has no business not to record the interest. He has to record the interest. How can I, as an auditor, say we are not able to assess the impact? After all, what is interest? Just principal into number of years into rate plus penal charges plus processing charges plus overdue charges, etc., right? As far as practicable, you must quantify it. This year, please place a lot of emphasis on external confirmation procedures. See, one thing I find it very surprising. I have a customer. I'm doing goods with him. Why would he not give a confirmation? I can understand 100% of the customers not giving a confirmation. But I find it very difficult to believe that only 1% of customers will give a confirmation. This acquires even more significance where it's a group company. If I've given 10 crores loan to a group company, why will I not get a confirmation? A company in which a director is interested, why will I not get a confirmation? These must actually, up your antenna. And another thing, let me tell you, apparently in terms of audit fees in the world, India is the most undercharged. You may want to compare Maruti audit fees with, let's say, a Mitsubishi audit fee. You will find the difference. Companies we're talking about. So there seems to be an overall. So my suggestion is, unless we are adequately commensurated for the risk, compensated for the risk, why should you be scared about writing something? It's fine. Just go full hog and say, I'm not happy. See, another constant charge on the auditor has been, look, you people always give us boilerplate reports. What's a boilerplate? Is a standard template. Break out of it. If you think something is important, please put it. Now you might ask me, no, my client doesn't want me. But remember, the Companies Act gives you a huge safeguard. You're appointed as an auditor for 5 years. Assert yourself. If a client wants to remove you, he has to go to the central government. It's not easy. See, what more can an act do for you? It's given you a 5-year tenure. It says if he has to remove you and you don't have to resign. See, sometimes you will say, okay, I will resign and go, please don't. I think today we should seriously set ourselves and saying, I'm working for this country. If there's a problem, there's a problem and we are in it together. The client must reform. We must qualify. Because if I were you, this is not a risk I would take. No, I'd like to go to a broader level safeguard. We spoke about independence, eligibility under section 141. Kindly ensure that you've been appointed in a general meeting, or if it's a casual vacancy, you can be filled by the board. Again, both CARO and an institute guidance on resignations have made it extremely difficult. The new Corporate Laws Committee report is again focusing on resignation. In fact, if you read the CLC report, it's extremely scathing. It lists 4 reasons for resignation, all of which are malafide of the client. So when we gave our response from CLCGC, we said, no, there could be other reasons. It could be an auditor's health. It could be a commercial consideration. It's not viable for me in this fee, etc. So again, the CLC, the ICAI has recommended that you want a format for resignation, fine. Please adopt the SEBI LODR format itself and be done with it. Internal audit reports. Section 138 of the Companies Act says internal audit is mandatory for certain categories of companies based on paid up share capital, turnover, outstanding loans, outstanding deposits, listed companies, etc. Right? But CARO tells you for all, CARO, there is no carve out. CARO is only applicable for most classes of companies other than the small ones which are excluded. CARO says you should have examined the internal audit report, goes one step further. It asks you whether there is a commensurate internal audit system. Second question, it asks you whether reports have been considered. And to all the statutory auditors out here, especially of these government companies, smaller government companies, etc., don't accept this half-page, one-page internal audit report. As a statutory auditor, you're entitled. See, you're coming in for an interim and a final, right? Internal controls are the responsibility of the management. It's in your right to demand a good internal audit. In one very large company which collapsed, the internal auditors, they blamed the internal auditors, but the internal auditors were very clear. They said, look, we were asked to only audit the asset side of the balance sheet. They didn't give us a mandate to audit the liabilities. So I didn't do the liabilities, or vice versa. So make sure that the internal audit system is robust. Could I request someone to mute, please? Please ask for the internal audit report. Again, most critical, engagement letter. Could I request the person to mute, please? Can you mute all?
Branch admin, please mute whoever is unmuted except the speaker.
Thank you. Thank you so much. Engagement letter. Where do I find an engagement letter? ICAI gives you a fantastic engagement letter format along with the standard. All you have to do is, there are 2 kinds of engagement letters that ICAI has given. One, where you're reporting on internal financial control. Second format, where you're not reporting. All I have to do is download, print, and sign. And tomorrow, if there's an issue, this is the first question which will be asked. See, ICAI has done so much to protect us. And there's one Vallalar proverb that says, Kadai virithen kolvar illai, which means I've got the store opened and then I don't have enough takers. Very similar situation. Second, management representation letter. So it's basically a representation from the management that says at the end of it all, look, I've told you everything that I know, and this is a true and fair. Now you may ask me, there's a fraud. Does my representation help? Unfortunately, a representation letter will help you for every other assertion except genuineness. What are your assertions? Existence, my assets and liabilities exist. Rights and obligations, occurrence, completeness. These are your assertions, right? These are the assertions about a financial statement which make it true and fair. And MRL doesn't really protect you against fraud. That is why today you need to do a little more work. Now again, today, what are you, when somebody says, look, how will I detect a fraud? It's not so difficult, but it can't be done by an article. That's the point where I'm coming back to saying in terms of audit pricing, partners ought to get more involved. I'll give you a few examples in what I'm going to do next. IT risks and controls. Now, I also think this is a great opportunity for the market to expand. If you're the statutory auditor, please have a proper internal auditor. If you think the financials are not getting prepared properly, identify chartered accountants who can help the client to prepare financials. If the payroll reconciliation is not done, you don't do it as the auditor. Ask the client to get it done. Refer people. And of course, the last thing is audit working papers. The standard says that you have to finish your working papers within 60 days of closure of the audit. You need to have documented working papers. I've in the past shared one template, but in a few days, I'll put in the new CARO and the new Schedule 3 and I'll share a template. So it'll give you some understanding of how a working paper would look like. Now, let's come to the core audit safeguards. I'm going to go component wise of the balance sheet. And for the next maybe 20 minutes, 25 minutes, I'll go through this and say, what is the most important 5 things? Whether it's from an audit component perspective, whether it's from a CARO perspective, a Schedule 3 perspective, or a fraud perspective. So what's share capital? So that's where we start, right? You need to disclose top 5 shareholders. Please look at the MCA data. That should be the last shareholding that you will record, plus any changes during the year. See, for an unlisted company, you don't really file anywhere, right? You only do it annually. So if your client has sold off something in August or September, the annual return is due only next, if your client has sold something in December, the annual return is due much later. So before your audit, the annual return doesn't get filed. So you may not know, but please be very careful. And secondly, how many of us insist on books? We must insist on members register, insist on directors register, ask them to go buy, come and maintain and write it. Or now it's allowed electronically. Strike off companies. If you have a share capital with 10 shareholders, of which ensure that your shareholders are real. Let's say I am auditing a company where you have 2 shareholders, 75 and 25. The 75 company has got struck off. Where am I today? Do I have a parent at all? Do I then have to start piercing a corporate wheel? I don't know. Share application money pending allotment. If it's not allotted within a respectable period of time as specified by the law, it becomes a deposit. Take care. Classes of shares have to be disclosed. Promoter pledges of shares, their shares, etc., wherever as appropriate will come. Secured loans, proper disclosure. Act is very clear. You have to say from whom I could talk the loan, what is the security, what are the terms and conditions. Now, today there is a concept of end-use monitoring that's introduced. You have to say whether the funds have been used for the specified purpose. It's a disclosure. Additionally, CARO also tells you short-term funds, long-term funds, whether people are mixing. See, what will happen if you mix short-term fund for long-term purposes? It's very scary, right? I have cash credit of 20 crores. See, while the cash credit is a 1-year loan, have you ever thought about it? Cash credit is your most permanent loan because you never really repay the bank. It's a limit that keeps on running. On running on what? On the safety of a client's stock and book debts mostly. So cash credit is only renewed every year. So today, what happens if you take the cash credit money and you buy a fixed asset? Then I will not have enough money to buy supply. Then I cannot sell. My working capital gets impacted, which will affect my entity's operation. Shareholder, director loans, deposits compliance, very important. Director can give a loan with a declaration. Shareholder can give a loan only for private companies. There are exceptions. Okay, another very important thing that you have to do is there is a private companies exemption notification, section 462. I think the last notification was 2017. Please go through that along with the 2015 notification. The next important aspect is unsecured loans. Just like secured loans, there is unsecured loans, right? See, and most of this, interestingly, again, the CLCGC of ICI is trying to do something. There's an organization called NESL. NESL is actually a company which is owned by all the banks and financial institutions, and it's a government company, and it's headed by a government official. All financial creditors in this country, SBI, Indian Bank, XYZ Finance, are supposed to pump their loan information into this IU. How often should they push the information? Every month. What information should they give? They should give the loan, what is the security particular, what is the interest, etc., etc. Today, as auditors, we don't have direct access to the information utility, but you can ask your client to log into NESL website. Again, this will happen in a short while. We'll send out a note on how exactly you can do it. You can sit with your client and see what all the banks have pumped for him for a particular loan transaction. So if your client, now I found this very, very interesting because it helps you to build some audit evidence. How? You leave a company. Let's assume in a company there is a charge, there is something. If I'm a partnership firm is my client and they're maintaining, they've not even told me about one loan. If I log in with this partnership span, I will know all his loans. So look for outside sources to validate your audit process. Purchases and payables, the revised Schedule 3 wants you to give aging. That's another very interesting thing. Have you looked at this? See, from financial, what were you doing? Financial reporting is what you were doing in Schedule 3. Now, with all these additional disclosures, it has become like management reporting. You have to give the aging of your payables. If not only payables where your bill has come, even if bill has not come, you have to say what is it and why it has not come. Government is interested today. Now, as far as secured loans, unsecured loans, confirmations are very strong procedures. Confirmation of balance. Tell your client now in April, this is my confirmation format. I am going to ask for the confirmation. If for a 50 crore loan from another private party, he is not giving you a confirmation till September, or even for a 2 crore, whatever is material, there is a problem. Similarly, for purchases and payables, your client is showing 30 crores or 3 crores or 30 lakhs is payable. What is my best test? My best test is the subsequent payment test. So you ask him, okay, what are your liabilities in March? It should have got paid in April, May, June, July, sometime August, September. It can't be without like that, correct? Very important. Provisions. You need to carry a provision for all known liabilities and losses. Deferred taxation. Be extremely careful in the way you compute and report deferred tax. Not you compute. By the way, the entire Schedule 3 has to be prepared by them, the preparers, and we are only the auditors. Another interesting debate that's been coming up in a big way, and I have been one of those very strong proponents of the debate, is what is the liability of the preparer today? There's so much of emphasis on an auditor. What are we doing with the preparer? Can you make, if any company has more than 20 crores bank loan, make a GM Finance as a chartered accountant? What is wrong? Market will find what price the CA will get paid. That's a different issue. I insist on internal audit reports. At least for 50 crore more than that borrowing, you need to have somebody. Contingent liabilities, pending litigations, export. Suppose your client has gotten into an EPCG scheme and there is an export obligation. All such contingent liabilities have to be disclosed. For these, representation letters are very, very good. Next is fixed assets. Changes which are there in Schedule 3 and CARO on fixed assets. In fixed assets, it's very simple. It's accounting, correct? For addition, deletion, depreciation. Verification is extremely important. In many, many companies, one finds that asset has sold and gone off, but it is not removed from the books. This year, now there's a very specific box where they want you to disclose title deeds. If a company has assets, but the title deeds are not in the name of the company, you need to record in your report on why it's not there and the value and the property. There's also talk about revaluation of fixed assets to be done only by a registered valuer. And today they are talking about the same level of controls for both tangible and intangible for revaluation. Another very interesting development is capital work in progress. The new Schedule 3 says, please give me aging of CWIP. Typically a very management reporting, right? More than that, they are asking you, how many projects have you abandoned? Again, many companies which go into bad times, you will find something would have got started in Rajasthan and sunk in the soil, abandoned. I'm showing these all as good assets of the company. I may not be carrying a provision. Then you go to one more element they're asking you about capital work in progress. They are asking you to report cost and time overruns. How will you calculate an overrun? You must have a standard, correct? That means your client needs to have a budget. That's exactly where this is flowing to. By the government mandating a certain reporting mechanism, they are wanting clients to adhere to an internal control procedure. It's something like this. Today, if you implement SAP, you have to have three-way matching. You don't have a choice. It will allow you to make a payment only if you entered that Migo, Miro, whatever, and it will allow you to pay. Today, in these subtle acts of enhancing disclosure, I think they have tried to modify or enhance business processes of clients, which I think is a good thing. Investments, they should be in the name of the company. Similarly, in investment, in all of this, if your client has interacted with a strike-off entity, you need to report. So investments, again, you come across many cases where there are bank failures. Client goes and puts money as investment somewhere. No AGM notice. I'm a shareholder in that company. No meetings held. No dividend has come. My money has not come back. So very often when you're talking about frauds, you put yourself in that position. If you're the owner of the company, unless there is something for you, will you give 20 crores to somebody and not do anything about it for 10 years? Think. It's the first person principle in audit is very effective. You need to sort of look for these red flags, which could be very important. Similarly, if you have invested in a particular company and your client says, I've invested, don't stop there. If it's a substantial amount, go to that company's MCA website and see whether you're recorded as a shareholder. Small things, but it shows that you've applied diligence when you're doing this work. You have inventories, which is the next component of your balance sheet. Absolutely compulsory is inventory verification. Why? It's the only item where I take the value from outside. So in inventory, what's important? Verification is important. Valuation is important. Count sheets are critical. Keep a scanned copy of the count sheets. Cutoffs are very important. Now I'll give you another interesting illustration. My client says, all my inventory is only less than 3 months old. Please go to his CCOD account and see whether he has paid his suppliers at all. If he has not paid any supplier in the last 6 months, how can inventory aging be 3 months? These are the things that have again come up in these stock and book debts reporting that we have been certifying to bankers. We need to be a little more skeptical and slightly sharp when we look at it. The Act also today wants you to give discrepancy by category, 10%. So stores is only 50 lakhs. Book stock, I have only 40 lakhs. I still have to report stores. That's the last part I was talking about is today there is a specific inclusion. They're saying where returns have been submitted to bankers, is it tallying with your books? The client on one side keeps on reporting to banker stock book that some number is going. In my books, there's a completely different number. I think progressively, banks should insist that this should be done by statutory auditors itself, then it keeps the problem simple instead of having just these standalone certificates being reported by others. But again, it's the bank's call. They want to get this done independently as well. Please be very careful about inventories. And people ask me, in many balance sheets, you see inventory as certified by the management, not allowed. You're expected to ensure that the management has verified it. See, because again, the problem is certification by the management, and this is also certified by the management, then everything is certified by the management. What did we audit? Then revenues and receivables, again, huge area. Please be a little careful. Today, Act anyway wants you to confirm aging. Not only do they want you anyway have greater than 180, less than 180. Now there is further Schedule 3. Incrementally, you have to report on MSME, non-MSME, disputed, non-disputed. Client says, okay, I have 30 crores receivable. Say, excellent. Please tell me how much has been realized. Your client's credit period is 60 days. You're auditing only in August. April, May, June, July. Even in August, if the money is not come, there is a problem. Cognize for it. See, previously, we used to trust and verify. Today's audit is verify and then trust. Very simple. Cash and bank confirmation procedures. Please obtain independent bank confirmations. Now, a lot of people came back to me with one question. They said, Priya, when I'm asking for bank statement from my client to do vouching or whatever, the name of the payee is not coming. This is a big issue. The bank has an obligation to provide the name of the payee. You must insist for it. There are others who have said, at least give me the IFSC code. I will take it from the client master that your client will be maintaining, or the supplier master. I'm going to leave the method of how you do it to you. But today, if you're going to review all, bank payments above 5 lakhs, then you have to examine it in a fairly great detail. You only won't put 20th November, 5 lakhs in the bank book, 5 lakhs in the bank statement, tick, tick. No. What is very important, who did I pay that 5 lakh to? This is the simplest way to divert money. I will write in my books as paid to XYZ Limited, whereas actually the check would have gone in favor of, let's say, the promoter's relative. How would you know that? So this is what I'm trying to tell you in terms of audit evidence. Whatever you do, see, today it's your call. As an auditor, I will say, I am only going to check payments above 5 lakhs. You check only that. Because GAAP gives you the benefit of sampling. But that 5 lakhs, if you're checking, please ensure you do it correctly. Bank confirmation procedures, very, very important. You don't write to a bank and say, please confirm balance of 13 crore 82 lakhs. Bank is supposed to fill up the numbers and give it to you. See, if you have very large value clients and all that, I believe the banks also charge something today. We are not here to save money for a client. Please go full extent and do what is required. Loans and advances, there's a huge change in reporting. Previously in Schedule 3, only to related parties we were required to report. Now they're asking us for a full list. Incremental to this, I wanted to only add 2 points. One, when you're doing Schedule 3, you have to give past year comparatives also. Which is why even when the Schedule 3 was coming, we kept saying last year itself, please work on this data for your client. So if you're talking about strike off this year, you have to give strike off of last year also. If you're talking about loans and advances this year, you have to talk about loans and advances of last year also. That's the first important thing I wanted to say. And the second most important thing I wanted to say is, all of us seem to think that if there is a note, so there are 3 levels. One, my client has made a mistake, I'm saying forget it. No, don't do that. It has to be brought to somebody's attention. The second is, I say, oh, he's not provided for interest on loan. I will put it as a notes on accounts. That really doesn't help you. That is the second level. If you think you're protected by this note, no, you're not protected. The note being there without your reference in the audit report doesn't help. The third, I put it in my audit report under emphasis of matter or qualified opinion, whatever, but I don't quantify it. That is also not acceptable. Now, the fourth is another set of problems. See, again, 80% of the accounts that we are signing are not qualified. So it really doesn't matter. Again, if any of you are auditing any large government enterprises, please be very careful, because they also come under C&AG. Please give very, very factual, very, very correct reports on whatever is the problem. Now, fourth is this. I have put 30 audit qualifications. All big numbers, important aspects. Can I say subject to all this, it gives a true and fair? Think. You have to clearly think in your mind whether it's an emphasis of matter without a qualification, qualification with a basis, and subject to this particular item. See, your client will say, look, I'm super confident of winning this court case, so I am not going to make a provision of 3 crores. Fair enough. There again, you're concerned because this case is 6 years old. So you're saying, no, I will take it as an audit qualification, and subject to this 3 crore item, my accounts are showing a true and fair view. Now you have 30 such matters. Can I say subject to note 9.3, 10.4, 11.3, 8. 12.5, 13.9, 14.2, my accounts give a true and fair view? They can't. No? If there's a table and one leg is shaking, you can qualify. If there's a table and there are 3 legs not there and one leg is shaking, it's a disclaimer or an adverse opinion. So please be very careful. With this, I hope that I've given some kind of an overview. Now, what I'm going to actually do is, I'm going to quickly walk you through the schedule 3, only the top 5 items in my opinion. Everything else I've actually covered, but what you need to watch out for, this. Following disclosures shall be made by your client. Sorry, are you able to see this sheet?
No.
No, ma'am.
Yeah. Sorry. Yeah. But this is a very important Schedule 3 change. All parties, the total loan you have to classify and show. Capital work in progress I discussed. This is very important. See, again, very interesting changes. This is in Schedule 3. I'm not showing you Caro now. They want the management to compute a lot of ratios, and then they want the auditor to comment based on these ratios and management discussions whether companies' short-term assets are enough to pay the short-term liabilities. I think that's being handled by Mr. Vivek tomorrow. So please be very careful in the way these ratios are calculated. And for this, you have a guidance note. This, in my opinion, is the toughest. Most of us may not have this kind of a situation where a company, that is your client, has advanced or loaned or invested funds in anybody who's called as an intermediary, with the understanding that the intermediary shall further, either he will directly or indirectly give to somebody for the benefit of your client. So your client, which is A, is the ultimate beneficiary, but they have given money to B, who may invest it himself or he can give it to C, C can give it to D, D can give it to E. They want you to ensure that they're not violative of PMLA. Similarly, now this by itself is a separate aspect of discussion in a separate webinar. So we'll take it there. Where the company has received any fund with the understanding that you are going to use the fund for somebody's benefit, or you're going to give it to somebody else for the giver's benefit. See, these aspects are very deeply reflective of failures that have happened. So these are the most important things. Of course, CSR has again become a big one to report. Now, my point is all this is sitting in Schedule 3. And once somebody is sitting, some item is sitting in Schedule 3, it's the reporting framework on which you are supposed to confirm true and fair. Now, let me take you, so if I was to single out one item for paucity of time, I had picked this. Similarly, in Caro, the most important ones that I would consider are the ones on diversion of funds. Are the ones that deal with diversion of funds and these ratios. They're extremely important. With this, I think I've gone into some kind of an overview on your key safeguards in audit. If I were to summarize the whole thing like a story for the next 2 minutes, it's just this. Whether I'm a new auditor or an old auditor, I have to go through my SQC1 for compliance. If I'm a new auditor, there is a specific requirement on communicating and understanding from the resigning auditor. You'll have to take that handover. You have to be independent of your client. You should be eligible for appointment, or in other words, you should not be ineligible under 141 or 144, which is restricted services, and the code of ethics. You have to be appointed in a general meeting, or if it's a casual vacancy, to be filled by the board and ratified in a general meeting. You have to give a 141(3) certificate. You have to file your ADT form. You have to be, and you are entitled to be appointed for 5 years, not 1 year. You have to go through 143(1) inquiries, which are important. You have to cognize for new accounts rules, new audit rules, new CARO, new Schedule 3. And for new Schedule 3, you need prior period comparatives as well. So please start preparing and engaging yourself. Then you need to get an engagement letter signed with the client, agree on the terms of reference, have an audit program, communicate with those charged with governance. You have issues, you can go to a point of saying, I am communicating this to you, you're not providing me data, I'm going to resign. You can even say that. Maintain audit working papers that document the progress of the audit, have clear roles and responsibilities, ensure that the accounts are ditto in Schedule 3 format, ensure your opening, most of these are the small common errors. Opening trial balance should be tallied to my balance sheet that I am certifying, correct? Because last year's numbers I have to tally. If there are reclassifications, please go ahead and do them. If you've made one mistake at some time, it's not necessary to carry through the same mistake over a period of time. Look for 143(1) inquiries. Ensure that your directors are not disqualified. Ensure how much of transactions are done with truck-off companies. See, tomorrow if there is an SFI or some proceeding, all the strike-off and all attracts everybody's attention, which is why it is important. Initiate external confirmation procedures. Look at it component-wise and say, if the money is mine and I am not running the company, if a director is running the company, how will I ensure that my money is protected? And please take care to ensure and stay aligned to the SA 700 reporting format. And if the qualifications are so pervasive, it can't just be a mere qualification. It has to be an adverse opinion or a disclaimer of opinion. And straight away, if I have to give the most practical advice, please go and renegotiate your fees. This audit is a lot more work. Even if you have to retain only 50% of your clients and double your fees, I think it's completely worth it. And don't be scared to lose engagements. It's fine. I think we need to develop that confidence, and market is filled with work. We just need to find it. With these few words, I'd like to conclude my presentation. And if there are any questions, I'll be happy to take it for a few minutes.
Any questions? Anyone? There's a question in the chat box, madam. Investment by a private limited company in a partnership firm as a partner in which the directors or the shareholders are other partners. What are the reporting requirements? Question in the chat window.
Yeah, it's an investment, right? You have to report whatever is a company can be a partner in a firm, right? First of all, if that is so.
Yes, ma'am. Yes, ma'am.
Yeah. So it will follow the exact reporting requirements under Schedule 3. You have to give the name of the firm, what is the investment held, and what is the price. Now, there is a very interesting amendment, which you might find very interesting. Trusts are not going to be allowed to be entered in the register of members. This corporate law committee is specifically talking about it. So as a holder. So in fact, somebody was mentioning a partnership apparently is also not entitled to hold property in its name. So somebody was asking, you're prohibiting a trust from becoming a member in the register of members. Why are you not prohibiting partnerships then? So it was a very interesting point that was raised. So yeah. Next question, please.
Any more questions? One more question in the chat window. Is the same person. Any idea of valuation of the investment in that case?
So it will depend on whether it is held for sale or held as an investment. So see, this is the impairment issue. If there is an impairment, then you take the provision. That's about it. See, what is my objective? I need to ensure that it should be, an asset should be stated at its relevant value. If there's an impairment, then you can reduce it for that impairment.
Any more questions? I think we can close the question session. Thank you, madam. I thank our Central Council member, C.H. Sripriya madam, who has guided us to take this program and make it a grand success. Especially the key safeguards and the 2-minute synopsis, madam. I think we have got a lot of input on that and making our safeguard the priority. Thank you so much, madam, for making us go through this grand program. And I request TRL sir to give the vote of thanks.
Good evening all. It was an excellent session. No words to say how excellent it is. So it's really the one point which Sripriya Kumar stressed many times is your audit fee and our stature, how audit fee should be put into place. It is our attitude. It will show what is our audit fee should be. So I think that is one of the she has stressed that point very many times, and that we should take it very seriously. And then negotiating the audit fee, because I was just relating the session with how the Ramayana and Mahabharata are carved out. In Ramayana and Balakanda, then nothing is mentioned about Rama in a big way. Whereas in Mahabharata, especially in the Bhagavatam, in Krishna's childhood days are described in so many things. So like that, Companies Act 2013 vis-a-vis 1956 is like a Bhagavatam with the Krishna Balalila. So it has got so many things to take care, and which is very lucidly Sri Priya Kumar has explained to us. I should say thanks to you, ma'am. What do you call? There is a lot of things which she has highlighted and said. And of course, there are certain things like Schedule 3 and Caro. There are session by itself, but still made it important point she has shown in the presentation. We should take from the cue from there. And then let's make our audit this year really a very successful one. And then let's make our fee also, as you said. I can have a lesser number of clients, and see, I made my purse or wallet fully. So
Yes, yes.
Thank you very much. Thank you very much, ma'am. So,
And thank you very much, Lakshmanarayan. And I like the reference to the Ramayanam. So, but in this Balakandam, they ask it in the form of a question and says, who is that? Konvasmin Sampratam Loke. He asks all the questions and finally gives one answer of Rama. I think this
it doesn't talk anything about Rama in that. Only and the qualities it talks about, but how Rama born and how is he born, nothing is there. But in the Krishna Leela, everything is there. It is like a Companies Act 2013 now.
You'll have a lot more guidances coming like this. It's going to be one never-ending marathon only. So all the best to everybody in this.
Thank you very much. Thank you very much.
Thank you very much.
Thank you, Priya. It was because of you only we were able to organize this seminar, the whole workshop or refresher course in such a wonderful
what's
manner.
very interesting is I think it's truly diversity empowerment. I can see very nice and very nice to see this. Thank you. Thank you so much.
Thank you. Thank you. Thank you.
Bye. Thank you, Kumar sir. Thank you very much.